Welcome back to the Deep Dive. This is part 9, our final installment looking into the Jeffrey Epstein saga.
Yeah.
If you've been with us, you know it's been, well, complex and deeply unsettling at times.
Definitely.
Today we're tackling what might be the most persistent part of this whole story, the big questions that just remain unanswered.
Yeah, the loose ends.
We're talking sealed documents, names blacked out, evidence we haven't seen, ongoing court cases, all of it.
That's right. And look, in any case this big, especially with so much secrecy, so many powerful people potentially involved, you're going to hit dead ends. Threads just disappear.
So what's our mission today?
Our mission really is to map out those gaps, to see what might still surface through things like lawsuits, FOIA requests, Freedom of Information Act requests.
Okay.
And also, crucially, to face the fact that some things we might just never fully know. It's about understanding where the public record, well, it has its limits.
Right. Let's start with that secrecy. The sealed documents. We know so much has come out, but it feels like there's always more just behind a locked door. Where are the key areas information's been deliberately kept hidden?
Well, what's really striking is just how much is sealed or redacted and how long it stayed that way. Take Jane Doe number 3 and 4's motion for joinder back in 2015.
That was to combine their cases.
Yeah, basically. And the court denied it, finding that the specific details who they had sex with were, quote, immaterial and impertinent.
Immaterial. Wow, so that's a legal way to just limit what gets out.
Seems like it, even within a lawsuit, using relevance as a shield.
And we know court documents are supposed to be public, right? Under common law, the First Amendment.
Presumptively public, yes. But protective orders became the tool to seal them. You remember the Miami Herald? They tried hard in 2018 to get stuff unsealed.
What was the court's reasoning then for keeping them sealed?
The main argument cited was the imminence of trial and potential impact on a jury. Which, okay, that raises a huge question, doesn't it?
About the balance. Public access versus a fair trial or privacy.
Exactly. And you see this shielding elsewhere, too. Like Virginia Giuffre's own privilege log from 2016, loads of communications with her lawyers marked withheld, attorney-client privilege.
Right.
And Ghislaine Maxwell fought requests for her financial info, said she'd file for a protective order. That got put on hold, but it shows the intent. The mechanism was always there.
So beyond the officially sealed stuff, what about evidence that maybe just never surfaced? Or facts that are still really debated?
Well, Epstein's death is a big one, obviously. The FBI says they'll release surveillance footage, finally, in 2025. Deputy Director Bongino stated it clearly shows Epstein alone and confirms suicide, trying to quash conspiracy theories.
But didn't the RIG report find problems?
Oh, yeah. The Inspector General's report from June 2023, while it agreed on suicide, it slammed the jail officials. Negligence, misconduct, outright job performance failures. Problems with the cameras were specifically mentioned.
So even if it was suicide, the conditions allowed for it and hid details.
Precisely. It points to massive institutional failure, whether or not there was, direct foul play. It creates doubt, which feeds the very theories they want to stop.
Right. And what about specific items, things we know existed but are gone?
Well, back in the 2006 Palm Beach search, remember? Police searched Epstein's place.
Yeah.
And the computer drives and other equipment connected to omnipresent surveillance cameras were missing. Vanished.
Suggesting he was tipped off.
That was the suspicion. And those drives, never seen again in the public record. That's a massive hole.
And the victims. We heard from Virginia Giuffre about her own records.
Yes, that was striking. She testified she burned her own private journal in 2013. Notes about the men she'd had sex with. She called it not anything that was a public document, but still.
A lost piece of the puzzle, definitely.
And she also mentioned practical issues, like not being able to afford to get boxes of documents from her nephews back in Australia.
So evidence can be fragile or just too expensive to chase down.
Absolutely. And then you have the straight-up contradictions. Alan Dershowitz, for instance, Jane Doe, #3, accused him of sexual encounters. He vehemently denied it.
Said he was only at the New Mexico house once while it was under construction.
Right. No Epstein, no young girls. Claimed he had unimpeachable witnesses.
But Giuffre sued him in 2019.
And her lawsuit claimed his proof just collapsed. Cited Epstein's staff, other women like Maria Farmer, saying he was there with young women.
So, who do you believe? The conflict is just right there.
It is, and it's similar with Maxwell. In her deposition, broad denials, never saw anything non-consensual, never heard about it, nobody reported it to her.
But other testimony paints a different picture.
Very different. One witness implied Maxwell expected her to perform sexual acts on Epstein during massages, like bring him to orgasm.
Wow.
Other testimony suggests Maxwell asked girls to bring other girls over, saying it, quote, takes the pressure off of her. So again, stark contradictions, makes finding the objective truth incredibly hard.
Okay, so it seems the legal wheels are still turning. What are the main ongoing cases or processes that might actually shake more information loose?
Well, Ghislaine Maxwell's appeal of her conviction is a big one. She filed that back in July 2022.
And while that's pending,
While it's pending, the FBI is using FOIA Exemption 7A. They're saying releasing their investigation files now could interfere with her prosecution, potentially a retrial maybe?
so those FBI files are basically locked down until her appeal is sorted.
That's the argument, yes. So the outcome of her appeal could be key to unlocking those records.
Are there other legal routes besides her appeal?
Definitely. Big lawsuits, like the one the U.S. Virgin Islands government brought against J.P. Morgan Chase, discovery in cases like that can force things out.
Makes sense.
And don't forget the Crime Victims' Rights Act, the CVRA. Victims have argued their rights were violated, like the right to confer with prosecutors. Courts have found those rights attached before charges are even filed.
And that could even reopen old deals,
Yeah,
like the NPA.
potentially. The court held it can authorize reopening an agreement if it violated those conferral rights.
Which connects back to the criticism of Alexander Acosta, right?
Yeah.
The OPR finding poor judgment for not telling victims about the non-prosecution agreement.
Exactly. Even if they didn't call it professional misconduct, it shows that tension. Institutional actions versus victims' rights. That fight isn't over.
And that original NPA was already controversial.
Hugely. The Southern District of New York wasn't party to it. It only covered the Florida investigation. That's why the 2019 federal indictment could happen. It charged conduct outside the scope of that original deal. Opened a new door.
Okay, so we've talked about what might still come out. Let's face the tougher part. What gaps, realistically, might just never be filled? What are we likely never going to know for sure?
I think the biggest ones, probably the full, precise contents of those missing computer drives, what was actually on them.
Yeah.
The full, unredacted story behind every name in his black book. We know some names, Clinton, Prince Andrew, others. Flight logs are out, contact books, but heavily redacted.
Didn't Attorney General Bondi release some, but Trump wanted more out?
Right. Bondi released what she could, apparently, but when Trump reportedly pushed for more, she said, nope, I can't do it. Why? We don't know for sure. The details of those relationships beyond just contact or flights, still very murky, might always be.
And just time itself is a factor, isn't it? Memory fades.
Absolutely critical. You heard Maxwell's testimony, quote, we're talking about almost 17 years ago. I cannot testify to an actual conversation or language. People forget. Or they claim to forget.
Right.
And the limited scope of some investigations is baked in now, like the OPR review of Acosta. It only looked at what prosecutors knew at that time before 2008. Anything learned later, not part of that review. That's a permanent gap in the official record.
And then there's the intelligence angle. That rumor about Acosta saying Epstein belonged to intelligence.
Yeah, that came from a less formal source, a YouTube report, so we have to be careful. It's speculative.
But it points to something.
It points to a whole alleged layer of activity intelligence connections that formal inquiries are just unlikely to ever confirm or deny. These things often operate off the books. The incentive for secrecy is immense.
So a complete picture.
A complete, totally definitive account of the full network, everyone involved, exactly what they did. I suspect we'll never have that. Some silence is likely permanent.
So wrapping up this deep dive series on Epstein, it's just clear, isn't it?
Yeah.
A lot has come out, but the story isn't finished.
Right.
Not by a long shot.
Yeah.
The secrecy, the legal games, just the passage of time. It guarantees some questions are going to hang in the air, maybe forever.
And that leaves a really important question for you listening. In this world where we're flooded with information, how do you deal with the gaps? The places where the truth seems just out of reach? And what's our duty, maybe, to keep asking, even when the answers are hidden?
That's a powerful thought to end on. Thank you for joining us on this long, complex, deep dive into the Epstein case.
Yeah.
Keep thinking, keep questioning, and keep trying to stay informed.